Good afternoon, everyone. I hope that everyone can hear me clearly, and welcome to this afternoon's 39 Essex Public Law Group webinar. I'm Sian Davies, for those that I've not met, and also presenting this afternoon we have Jack Anderson and Arianna Kelly, and we're going to be talking about the Worcestershire Court of Appeal decision on ordinary residence. Just a few housekeeping points. You can ask questions by using the Q&A function. We will keep checking the questions to make sure that we are able to answer as many as possible. For those of you that might want to use the closed captioning function, at the bottom of your screen there should be a CC button which you can use to enable a live transcript. And the third housekeeping point is that you will be sent access to the recording of this webinar and access to the slides. That will probably be sent out tomorrow. So if you miss anything, you'll be able to catch up via the recording. We're going to be an absolute maximum of an hour because I'm sure everyone has got very busy work days to get back to, but hopefully this will be informative and will fit a lot in. I'm going to, with that, hand over to Arianna, who will begin the presentation. Thank you.
Good afternoon. I know we already have two questions even before we've started, so which I think just demonstrates the incredible interest in this case and how really complicated this all is. So I'm going to start off with going through the background because I think as many of you will be aware, this has been a saga that has been going on now for quite some time, and it may be helpful just to get a bit of a grounding in what has come to pass and what the significance of this decision is going to be. So just starting off with some of the basics, because this is a decision which does get quite into the weeds in terms of what the statute does and doesn't say. Under section 1172 of the Mental Health Act, aftercare responsibilities fall jointly on local authorities and CCGs. CCGs are governed by different rules. I'm going to park all of the CCG duties for now and just focus on the local authority duties. Now, in terms of determining which local authority has a responsibility to provide aftercare to the person, section 1172 of the Mental Health Act states that it shall be the duty of the local social services authority to provide or arrange for the provision of aftercare services for any person to whom this section applies until such time as the clinical commissioning group and the local authorities and the local social services authority are satisfied that the person concerned is no longer in need of such services, but they shall not be satisfied in the case of a community patient while he remains a community patient. So someone who is still within the auspices of the Mental Health Act, just within the community. The end point of this is really one of the crux of the issues of dispute as between the different local authorities, the Secretary of State, and what the court was really considering in this case. And I think, as you can see from section 1172, there is some lack of clarity insofar as that this is a subjective decision taken by the CCG and the local authority as to when that duty comes to an end. Section 117 duties are defined pretty broadly. They're defined as services which have both of the following purposes. One is meeting a need arising from or related to a person's mental disorder, and the other is reducing the risk of a deterioration of the person's mental condition, and accordingly reducing the risk of the person requiring admission to a hospital again for the treatment for mental disorder. So again, very broad, and in some ways both very broad and a bit ill-defined, and generally seen as encompassing almost any sort of service the person would require in order to meet a need arising from a mental disorder. The pre-CARE Act framework and case law was on the basis of where the person was considered to be resident prior to their admission to hospital under section 3 or a number of other sections. However, in the CARE Act, section 1173 was changed, and it now states that the relevant local authority is local authority in which the person is ordinarily resident rather than merely being resident. I've set out the full provision here on the slide. And again, for England and Wales, the person, the area in England and Wales where the person was ordinarily resident, or in any other case for the area in which the person concerned is resident or to which he is sent on discharge by the hospital in which he was detained. Now, Section 1173C is a bit of a savings clause for people who are essentially of no fixed abode at the time of their detention in hospital, where that's impossible to determine. You look first at where the person was resident, and if it's truly impossible to determine where the person was resident, even if not ordinarily resident, it will be the area on discharge. The Worcestershire case is not focused on no fixed abode individuals, but again, that is one of the ways in which Section 117 responsibility can land on a local authority. Now, the traditional understanding around all of this was that this was going to be on the basis of the Shaw and Barnett test, which is a very long-standing test for ordinary residents, which essentially looks at where the person lived for a settled purpose and where they were essentially living out their life, what their connections to the areas were. In Shaw and Barnett, this was also looking at voluntary adoption of an abode for a person. In the Cornwall case, there was some consideration as to how capacity impacted on that. And Sean's going to be speaking with you about some of the other implications of the Cornwall case. But essentially, the Cornwall case approved a modified version of the Shaw test for people who lack capacity to determine their residence. In my view, it's an extraordinarily similar test. It's looking at where is the person living, where are their social connections for, and what is the purpose for which they're living there. And a person with or without capacity can develop a purpose in living in a place, even if they hadn't had the capacity to voluntarily select their residence. And that was the traditional view of how Section 117 ordinary residence applied. It was simply looking at where the person was, the purpose of their living there, the duration of their living there, and what their connections to that area were. What was typically not considered to be part of the equation were the deeming provisions of Section 39 of the CARE Act. Now, again, there were former deeming provisions under the National Assistance Act, which applied to care homes and nursing homes specifically. Under the CARE Act, under Section 39, these were expanded out to include a broader range of placements at which a person could be placed. So to include supported living accommodations, and shared lives placements, in addition to care homes and nursing homes, with supported living accommodations often being a source of controversy because they're not registered, but a broader, more expansive view of really looking at the placement of a person in certain sorts of residential accommodation rather than just care homes. Now, what's notable about Section 39, and I've included this on the slide here, is Section 39 specifically makes reference to the deeming provisions applying to an adult who is to be treated for the purposes of this part being Part 1 of the CARE Act. And so specifically applying to Section 18, 19, and 20 duties under the CARE Act, the person is to be deemed as resident in the place that they lived before they were placed in a specified accommodation by a care home. But it doesn't say that the person is generally to be considered not to be ordinarily resident in a place. It just said they are to be deemed for the purposes of this Part 1 of the CARE Act in that way. And so the traditional view, which was set out in guidance and in case law, was that you did not apply the CARE Act deeming provision for people who were being looked after under Section 117 aftercare. CARE Act duties also follow Section 117 duties, and there are specific deeming provisions within Section 39 CARE Act, so that there is no scenario in which a person to whom Section 117 duties are owed by one local authority has CARE Act duties owed by another local authority. Any person to whom a Section 117 responsibility is owed, a CARE Act responsibility is also owed to eliminate really any fights between local authorities, whether something would fall under Section 117 or the CARE Act. But again, a very specific consideration here in Section 39 CARE Act about the interplay between the CARE Act and Section 117, and specifically about how deeming provisions would apply in that scenario. DHSC's guidance, which has been, as far as I'm aware, essentially static on this point since the CARE Act was implemented in 2015, essentially agreed with the traditional view of this scenario. What it said is that if you have a person who is living in the community, they're detained under the Mental Health Act under Section 3. They're then discharged. Their ordinary residence would fall to be considered at the time that they went into hospital. So the place that they were ordinarily resident before going into hospital, even if they're then placed somewhere else. If the person is then placed into Council B on discharge, and they're sectioned again under Section 3 of the Mental Health Act, Council B is now the place that they were ordinarily resident, even though they were placed there by Council A. So paragraph 1964 of the Care and Support Statutory Guidance set out this position. Although any change in the patient's ordinary residence after discharge will affect the local authority responsible for their social care services, it will not affect the local authority responsible for commissioning the patient's Section 117 aftercare. Under Section 117 of the 1983 Act, as amended by the Care Act 2014, if a person is ordinarily resident in local authority area A immediately before detention under the 1983 Act and moves on discharge to local authority B and moves again to local authority C, local authority A will remain responsible for providing or commissioning their aftercare. However, if the patient, having become ordinarily resident after discharge in local authority B or C, is subsequently detained in hospital for treatment again, the local authority in whose area the person was ordinarily resident immediately before their subsequent admission, local authority B or C, will be responsible for their aftercare when they are discharged from hospital. And there's no deeming provision attached to that. It doesn't matter why you moved there. It doesn't matter that you moved there because you were placed there by the local authority. What matters is that that was the place that you were actually living, and in a Shaw sense, you had become ordinarily resident in that place. So that became the relevant local authority. So what you got, and I've certainly seen many of these cases in my own practice, are people who have been struggling with their mental health for significant periods of their adult life. They go into hospital, they're discharged to a new placement, sometimes a specialist placement, which is considered to be able to offer them higher level of support, but ultimately they're not able to remain in the community and have to return to hospital. And it's now the new local authority, which may have no prior connection to the person, that has the new Section 117 responsibility, despite the fact that really the first time they may have learned of this person's existence was at the time of discharge from hospital. Certainly for some local authorities that have a particular number or particularly large numbers of specialist placements to treat people with mental health issues, this has been a persistent issue. And certainly, again, I'd say in my own experience, I think many local authorities have a belief that one or more of their neighbors are intentionally placing people in their area in order to try to avoid the responsibilities to them. So certainly an area of quite a bit of contention. In 2020, DHSC announced that they were reversing their own policy. Now, notably, they've never actually retracted the guidance that I've just read out, but in a series of 8 ordinary residence determinations they made, the Secretary of State set out that he considered that the existing statutory guidance was at odds with both statute and case law. One of these was an ordinary residence dispute between Worcestershire and Swindon. He also considered that the Wiltshire and Hertfordshire case was not good law following the change from residence to ordinary residence. And following this view by DHSC and knowledge that there would be a judicial review in the Worcestershire case, there has been a very long-standing stay on ordinary residence determinations which raise these same issues. And it has been confirmed by DHSC that this will remain in effect pending a permission application to the Supreme Court. So this has now been over 18 months that the Secretary of State process has not considered any ordinary residence dispute which raise these same issues. Now, just briefly setting out the facts of the case in the Worcestershire and Swindon case, I think in many ways it's a helpful example because it's not a particularly uncommon one. This related to JG, who was living in Worcestershire, known to community services. In 2012, JG was informally admitted as an inpatient, stayed there for approximately a year and left hospital, going back to Worcestershire as a previous accommodation. Only able to remain in the community for a few months after that, JG was readmitted to the hospital as an informal patient, but with a stay that extended on for a significant period of time, and she was detained in hospital under Section 3 by March of 2014 and assessed as lacking capacity where to live in April 2014. Following at the end of this stay, she was discharged into a residential care home in Swindon under the Section 117 aftercare duties held by Worcestershire in that case. She was then moved to a second care home in Swindon in February 2015 and was again detained in hospital under Section 2 in May of 2015, and again detained in hospital under Section 3 in June 2015. I think approximately 3 months after she was detained in hospital, Worcestershire surrendered her care home placement in Swindon. She was actually discharged under Section 3 in November 2015, but remained on as an informal patient for nearly 2 years further, but detained under the Mental Capacity Act eventually, and then only left hospital in August 2017, at which time the dispute arose as to which of these two local authorities had responsibility for her. So essentially, long-standing residence in Worcestershire, detention under the Mental Health Act, discharge to two placements, in fact, in Swindon, re-detention under the Mental Health Act, who holds the responsibility. So in many ways, a very typical sort of scenario in this. The policy reversal set out by DHSC said that it took the view that its guidance was wrong and should not be followed for three primary reasons. One was on the basis of the Cornwall Ordinary Residence decision, which looked at essentially creating a continuity of deeming provisions as between children, the Children Act and the National Assistance Act. And what the Supreme Court found in that case was that there was no lacuna as between the two of them, and that if you were deemed in one local authority under the Children Act, that deeming would carry through straight to your adult placement rather than disappearing on your 18th birthday and your ordinary residence being determined anew from that date. It was accepted by DHSC that there was no Section 117 deeming provision in this case, but the consequences attaching responsibility to the local authority where the person was ordinarily resident pre-detention is effectively the same as a deeming provision. This was the view of DHSC, and that the placing authority had responsibility for the person even if they were out of area. And by the reasoning of Cornwall, the person retained ordinary residence in the placing authority, even in the absence of a specific statutory deeming provision. The second argument that DHSC had as to why its existing guidance was wrong and shouldn't be followed was that the determination of ordinary residence fell to be determined immediately before being detained. And what they suggested was that the relevant period of detention was the first period of detention that a person had if they had had multiple periods of detention, and that a policy could be discerned that a person's ordinary residence is not affected by being placed elsewhere by a local authority. And the statute is not specific as to whether it's the ordinary residence immediately before first being detained or the most recent detention. The final argument by DHSC was that the previous Section 117 duty doesn't end just because a person is detained again. The Section 117 duty continued through the second period of detention and remained in effect on discharge. It does not end by operation of law simply due to a person being re-detained. The ending of the duty is set out in Section 1172, which was my first slide, and the duty only ends when the person no longer needs such services, not simply because they've gone back into hospital. This was particularly the case for short periods of detention. The first instance judgment in this case was heard before Lyndon J, with judgment being given last March. I'm just going to give the headline findings because all of these are re-examined in the Court of Appeal, which Sean is going to take you through in some detail. But the short version was the first instance court rejected the Cornwall argument, primarily on the basis that the Hertfordshire case was still good law. And in the Cornwall case, the Supreme Court had not questioned the correctness of the Hertfordshire case, and Section 117 duties are health duties, which are freestanding to both the CARE Act and the National Assistance Act. And essentially, if Parliament had wanted to put a deeming provision in, it would have done that. It did not do so, and there is not that same continuity that you see as between children and adults, because these are separate duties to both the National Assistance Act and CARE Act duties. The second argument, that immediately before detention, that Section 117 was not ambiguous or unclear, and that ordinary residence falls to be determined when the person leaves hospital, with the ordinary residence being the time prior to each detention. Now, the third finding is somewhat at odds with the second finding, and this is something that was explored at some length by the Court of Appeal. But the court found more sympathy for the argument that the previous duty hadn't ended, though it did ultimately reject this argument. It argued that the earlier duty had ended by operation of law on release from re-detention. But in order to bring a Section 117 duty to an end, a decision must be taken to this effect, and it was not automatic on the basis of readmission, though, as Lyndon J found, this was almost invariably the position that the duties would come to an end on the basis of that re-detention. So that's the background. And now I'm going to hand over to Sean, who's going to walk you through what the Court of Appeal actually found when it considered the case.
Thank you very much, Arianna. That's been a really helpful setting out the background to the Court of Appeal's decision. We do have some questions, and I'm going to sort of park those until we've gone through the Court of Appeal's judgment, either because the answer might become apparent once we talk about it, or because it's probably more helpful to look at those questions once we've looked at what the Court of Appeal had to say about these issues. So if we could just move the slide on. Thank you. So that the Secretary of State's appeal was allowed. Obviously, the respondent to the appeal was Worcestershire. Swindon had been an interested party at first instance, but didn't play any part in the Court of Appeal proceedings. So the Secretary of State's appeal was allowed. And just to give you, if we could have the next slide, the headline. The headline really is that there could only be one duty under section 117 at any one time. In other words, two local authorities could not hold concurrent section 117 duties. And that duty remained with Worcestershire unless and until the duty came to an end. And the only two ways in which it could come to an end were on the facts, i.e. by way of a lawful discharge of duty, or as a matter of law. And so obviously there was a need for the Court of Appeal to examine in some detail how, as a matter of law, a section 117 duty could end. If we could have the next slide, please. What was held was that a subsequent period of detention, and Arianna has very helpfully set out the facts in JG's case, i.e. that she had been originally detained when she was living in Worcestershire. At the end of that period of detention, she'd been placed in a residential placement in Swindon, and it was from the Swindon placement, in fact the second Swindon placement, that she was subsequently detained again under section 2 and then section 3. But what the Court of Appeal held was that that subsequent period of detention did not, as a matter of law, have the effect of ending the section 117 duty. The duty could only end with a decision being taken by the relevant local authority and or CCG that they were satisfied that the patient was no longer in need of aftercare services. In other words, that the criteria for someone being a recipient of aftercare were no longer met. And that was based on the circumstances, again, Arianna's very helpfully set out under section 1172 for the cessation of duty. So moving on, please. The next step in the approach was to consider whether there had, in fact, been a cessation of duty. On the facts of JG's case, she had become ordinary it was accepted that there had not been. She had become, as a matter of fact, ordinarily resident in Swindon immediately prior to the second period of Mental Health Act detention. But that in itself didn't cause there to be a need to examine the competing claims of connection to Worcestershire and to Swindon. And that was because one goes back to the fact that there is only one section 117 duty, and the section 117 duty continues for so long as it is not discharged. And so once one accepts those parameters, the question of competing duties doesn't arise. Next slide, please. The Court of Appeal carried out what it describes as a sense check on that approach. And it found that that conclusion was in accordance with common sense. And the reason for that goes back to what the Mental Health Act Code of Practice says, which is that care planning for somebody who is detained under Section 3 of the Mental Health Act should begin at the point of Mental Health Act detention and should continue throughout the period of Mental Health Act detention. In other words, that there should be effectively seamless care planning from the point that someone is detained to the point that they're discharged and beyond. If there were to be a change of responsible local authority because of the fact that somebody had been re-detained following a period of aftercare, that in the Court of Appeal's view would not accord with common sense and would not be consistent with what the Mental Health Act Code of Practice says about the need for that seamless care planning. Next slide, please. So in terms of ordinary meaning of the words, obviously JG lived in the sense that she lived her settled life applying the Shah and Barnett criteria immediately before her second period of Mental Health Act detention in Swindon. It was where she voluntarily and for settled purposes, I'm sure everyone's very familiar with the Shah and Barnett formulation, that was where she lived her settled life. It might not have been the place that she would have chosen, but nonetheless, it was the place where she was living her settled life. Was there a reason to depart from the ordinary meaning of the words and the fact that her ordinary residence, as a matter of fact, had been in Swindon immediately before the second detention? Well, the answer was that there, again, it comes back to this analysis of the duty not having ended, the duty not having ceased. And because the duty had not ceased, the fact that her place of ordinary residence, as a matter of fact, might have moved to Swindon didn't change the legal obligations upon Worcestershire. Moving on, please. The Court of Appeal carefully considered the Hertfordshire case. The Hertfordshire case concerned the difference between the pre-Care Act amendment formulation of Section 117 and the post-Care Act 2014 formulation of ordinary residence. So prior to the amendment, the formulation of Section 117 referred only to residence. And post-amendment, it changed to ordinarily resident. The issue that fell to be determined in the Hertfordshire case was whether the change of wording, if we could move the slide on, please, amounted to an importation into the Section 117 of the deeming provisions that we find in Section 39 of the Care Act. And the Court of Appeal in Worcestershire very carefully considered whether those deeming provisions could be imported into the language of Section 117. And it described trying to do so as a seismic change, and moreover, a seismic change in terms of statutory meaning, which was not one that was recognised by the Secretary of State for Health at the time that the Care Act was brought into force, and was not a seismic change that was reflected in statutory guidance, which was issued after Section 117 was amended. So the Court of Appeal considered that the suggestion that the deeming provisions from the Care Act could not be imported into Section 117, notwithstanding the change of language. In other words, the change of language from resident to ordinarily resident didn't carry with it the weight, or couldn't bear the weight of also importing the deeming provisions that apply to the Care Act. And just to mention in passing that, of course, under the predecessor legislation, the National Assistance Act, there were also deeming provisions, which also didn't apply to the Mental Health Act in its pre-Care Act amendment formulation. So the next issue that the Court of Appeal had to grapple with was if we could have the next slide, please, the invitation from the Secretary of State for Health and Social Care to determine effectively on a sort of policy basis that there ought to be a much more broad purposive approach to the question of the meaning of ordinary residence. And that was an approach which was founded in the Cornwall case. The Cornwall case, if we could have the next slide, please, some of you may recall, concerned the deeming provisions under the National Assistance Act, but in particular the interplay of those deeming provisions with the deeming provisions that apply under the Children Act 1989. And the facts, very briefly, of Cornwall were that the person at the heart of the case, the P, had been placed out of borough by a local authority that had responsibility for him as a looked after child. and had placed him into another local authority area. And the question which then arose was as to which local authority area was responsible for meeting his needs as an adult who had a need for care and attention under the National Assistance Act, as the then relevant statutory scheme for adult community care. The approach taken by the Supreme Court in Cornwall was largely policy-based and was expressed as such in terms of seeking to prevent a local authority from exporting financial responsibility for somebody by placing them out of area. In other words, that the local authority which placed P out of area as a child could not rely on that decision to avoid being responsible for meeting his needs as an adult. And the question which the Court of Appeal had to grapple with in Worcestershire was whether that same policy-based approach, in other words, the wish to avoid local authorities being able to export or avoid the financial consequences of meeting someone's needs by placing them out of borough, could also apply to Section 117. And if we could have the next slide, please. That approach was held not to apply to Section 117. It was held not to be possible to read across that policy-based approach to a different statutory scheme. And importantly, the Court of Appeal relied on the fact that the National Assistance Act and Children Act both have deeming provisions within them. Of course, we now have the deeming provisions in Section 39 of the Care Act, whereas the Mental Health Act doesn't have those deeming provisions. And so it was found to be too great a stretch to seek to import that policy-based approach into a statutory scheme which doesn't contain deeming provisions that could be regarded as capable of supporting a transition from one statutory scheme to another. So just to summarise the sort of key points, if we could have the next slide, please. Really just three key points that if I'd like people to sort of take away. The first is that the local authority responsible for meeting 117 aftercare needs retains that responsibility unless and until there's a determination that the patient is no longer in need of aftercare services. I was keeping an eye on the message, the chat for questions, and one of the interesting questions that was raised was what evidentially there would need to be in terms of showing that there had been in fact a discharge of Section 117 duty. And I'm going to suggest that we park that question and come back to it as a panel once we've heard from Jack. Because I imagine that's going to be one of the sort of key issues that follows on from this judgment. Next slide, please. So that responsibility is capable of surviving an out-of-area placement. Obviously, we know that from the fact that JG had in fact moved from Worcestershire to Swindon. And therefore that survival happens. And we also know that Section 117 responsibility is capable of surviving a subsequent detention. Again, that's what happened on the facts of JG's case. And the Court of Appeal approach was to operate what it described as the sort of common sense check, which was to measure its approach by reference to the Mental Health Act Code of Practice and the requirement that there be seamless discharge planning for somebody detained. So that is really where we're at, and I'm going to stop there and hand over to Jack, who's going to look at the next steps and implications following on from the Court of Appeal's decision.
Thank you very much, Sian. So I suppose the first thing to say is, of course, that we may not have heard the last word on these issues in the judgment of the Court of Appeal, because Worcester has applied for permission to appeal to the Supreme Court. I don't know from the research I've been able to do when any decision on that application for permission can be expected, but plainly it's an issue of some importance. And if it does go up to the Supreme Court, it will be interesting to see whether and to what extent that court feels freer to revert again to some of the policy considerations that informed the Cornwall decision. One can detect in the judgment in the Court of Appeal a certain dissatisfaction with the reasoning in the Cornwall case, both as to its clarity and as to whether it reflected an excessive importation of policy considerations. And it would be very interesting to see if the Supreme Court were to take the same approach. In the meantime, though, the Secretary of State has indicated that it will continue to stay decisions on ordinary residence determinations that raise the issues canvassed in the Worcester case, unless there are exceptional circumstances, pending an indication as to whether there's permission granted in the Supreme Court, and no doubt in due course the outcome of any appeal if permission is granted. That means that there's still going to be a significant delay before such decisions are taken, and the guidance from the Secretary of State doesn't indicate what sort of circumstances might amount to exceptional circumstances warranting a determination in the meantime. For my part, I find it difficult immediately to conceive of cases which they're likely to think needs to be resolved, because as long as the relevant authorities are ensuring that the needs of the individual is met, any question of the distribution of resources between them should be capable of being resolved at a later stage. The department has, though, also made clear that in the meantime, although it is staying those decisions to which these issues relate, disputes must still be referred if they can't be resolved within the 4 months provided for in the dispute resolution regulations. That's 4 months from the date when the dispute arose. So authorities should still be referring any disputes to the Secretary of State, and the Secretary of State will then consider on a case-by-case basis whether any particular determination raises the same issues as arise in the Worcester case, such that it should be stayed. Now, one question that we've been asked is whether there are any plans afoot in relation to some sort of non-retrospectivity provision to avoid any significant claims in relation to decisions that have been taken under the, as it were, the status quo ante. To which the answer, as far as I'm aware, is no. There's certainly nothing on the department's website to indicate that that would be under consideration. But of course, the extent to which there would be any question of retrospective application will depend on the facts. Where determinations have already been reached, the fact that there's then a subsequent case which indicates that a different approach should have been taken to a previous determination doesn't in itself mean that that determination will fall to be set aside. The general principle is that a determination in an ordinary residence dispute would stand unless until it's set aside. And of course, setting aside a determination of the Secretary of State would require a claim for judicial review to which strict time limits apply. So far as it were, previous determinations are concerned, it doesn't seem likely that retrospectivity should be too much of an issue. And of course, if it's issues in terms of previous decisions that have been made by local authorities about whether they do or don't accept that somebody is ordinarily resident, again, it may be that decisions have already been taken, and it may be beyond the point at which those can be challenged or reopened, but that will potentially depend upon the particular factual circumstances at issue and whether and how any such decision was taken and recorded. One issue, obviously, that arises in connection with the delay in determining these claims is what's happening in the meantime in relation to the position and funding. And of course, the department emphasizes, and we, I think, here emphasize that any issues that might now arise in connection with ordinary residence disputes shouldn't ever affect the actual provision of services on the ground. Authorities should always ensure that one of them is taking the lead, as it were, in the meantime. But the longer these decisions go on, or the greater the level of delay there is, the greater the risk that an authority could be incurring fees which it may find it difficult to recover at a later stage. And so we thought it was worth just briefly touching upon that issue, and in particular upon an issue that arises from the department's guidance, where it seems to me that the guidance may potentially be incorrect. So Section 41 of the Care Act provides that where a local authority has been meeting an adult's needs for care and support, but it transpires, whether following a formal determination under Section 40 or otherwise, that the adult in question was ordinarily a resident in the area of another local authority, then the lead local authority can recover the cost of meeting those needs from the other local authority in terms of any payments that it's made towards meeting those needs at a time when it was that other local authority that was responsible. Section 69 of the Care Act then provides that any sum due to a local authority under that part of the Act is recoverable as a debt due to it. And I pause there to note that the ordinary limitation period in respect of recovery of debts is 6 years. So ordinarily, if it were necessary to enforce the payment under Section 41 of the Care Act, that would be the maximum time within which that could be done. Now, the Secretary of State in their online guidance says that Section 41 of the Care Act, read alongside Section 117(4) of the Mental Health Act, allows for expenditure borne by a local authority in the provision of Section 117 aftercare for a person ordinarily resident in the area of another local authority to be recoverable from that other authority. In other words, the department's guidance suggests that if you read the Care Act and Section 117 together, the same provision, Section 41 that we've just looked at, could be applied in relation to the provision of care under the Section 117 duty. I have to say, I don't myself see that read across, since, as I've set out on the slide, what Section 117(4) provides is that where there's a dispute about ordinary residence, Section 40 of the Care Act applies to the dispute, as it would apply to a dispute about where a person is ordinarily resident for the purposes of Part 1 of the Care Act. But it doesn't say anything about Section 41. And the reference in Section 41(1) back to Section 40 in the context of a determination doesn't, it seems to me, operate so that you could sensibly read Section 41 as falling within Section 117(4) of the Mental Health Act 1983, just because of that reference to Section 40. And so it seems to me doubtful whether it's in fact correct that the Care Act provides an answer to how the lead local authority might recover any payments that it's been making. It seems to me that the answer to that may well be, though, that a local authority that was providing the funding in circumstances where, in fact, it was another local authority that was responsible may have a claim either firstly in relation to judicial review, if it were effectively to put it to the other authority that they need to take a public law decision as to their responsibilities, or secondly, a claim in restitution. And I think we've set out on the next slide, I think a relatively recent case. My apologies, I've not inserted it on the on the slide, but the Lincolnshire case, and I'll just bring up the formal reference to it, which is 2020 EWCA 3550. It's the case of Surrey County Council and NHS Lincolnshire Clinical Commissioning Group, which was in fact a case in connection with CHC funding rather than Section 117 aftercare. But Surrey County Council successfully argued that it could bring a claim for restitution against the Clinical Commissioning Group in circumstances where the Clinical Commissioning Group had refused to undertake an assessment for eligibility for CHC funding, which was a public law error. It should have undertaken such an assessment. And had it undertaken such an assessment, the court was satisfied it was likely that the conclusion would have been that the individual in question was eligible. So for all that period of time, Surrey County Council were paying to meet the needs of that individual when it should have been the CCG that was meeting those needs. And the court held that in those circumstances, there was a good claim for restitution against the CCG. The CCG's attempts to argue that such a claim had to be brought by way of judicial review failed. The claim that the judicial review time limit should be applied failed. It was the ordinary 6-year time limit that applied. And the claim by the CCG that any funds that it had saved, as it were, by not having to pay for that individual's care had already been expended on the needs of other service users such that there'd been a change of position also failed. So whilst you would need to consider carefully the facts of any individual case before deciding whether a claim for restitution was appropriate, it does seem that that would be a potential mechanism that a local authority could use if it had been funding care in the meantime and the other authority refused at the end of the day to pay that back. The third issue arising, or big issue arising in relation to practicalities from the decision, is the importance that evidently now attaches to formalising decisions to cease Section 117 support. Now, it was found as a fact that there had been no such decision at first instance in the Worcestershire case, and that finding wasn't challenged on appeal. But plainly, in view of the clear decision of the Court of Appeal that a decision is needed in order for the obligation to cease, it will be important for authorities to ensure that they clearly record such decisions. And in order to make sure that such decisions are taken properly and in accordance with the authority's responsibilities, that also means it will be important to ensure that there's a proper record of exactly what the needs for Section 117 aftercare were in the first place. Now, one question that we've been asked is, well, what would happen if a person ceases to have any needs for aftercare services and ceases to be receiving any aftercare services, but there isn't a formal record of that, of any decision having been taken. And perhaps that's an appropriate juncture sort of to convene in a panel and consider this. I mean, it seems to me that there may be circumstances in which the court would accept that there had been an implicit decision that had been taken, potentially, if it was very clear that there were in fact no such needs and that there had been then a period when there was no provision being made in relation to any such needs, so that effectively you were dealing with two separate events. I can see that a court might be willing to conclude in particular facts that implicitly there had been a decision that services were no longer required, but I don't know if others have any different views.
I think it's one of there are two sort of key themes that I think are going to have to fall to be determined following on from the Worcestershire decision, and I think that's one of them, the question of to what extent a discharge of duty can be inferred or implied from effectively a sort of cessation of services rather than a formal cessation of duty. And I think the other one is the kind of the untangling of duties under the Mental Health Act and duties under the Care Act. because certainly in my experience, I quite often see, for example, a care and support needs assessment being used actually in relation to somebody whose needs are under the Mental Health Act. And that causes confusion between the sort of statutory basis for the support being provided, and perhaps more importantly, in the context of ordinary residents, it's entirely possible that it might be two different local authorities, one of whom owes the aftercare duty and one of whom owes the care and support duty under the Care Act. Because of course under the Care Act you do have the deeming provisions, and so ordinary residence isn't the only criteria under the Care Act, because one of the deeming provisions might apply. Somebody asked an interesting question about a person who's been placed by local authority 1 into specified accommodation in local authority area 2 under the Care Act, who continues to have responsibility under section 117. So I don't know if either of you have got any views on that.
I think my view on that would be, so assuming I'm getting the scenario right, is you have a person, so council A places person into council B, then is detained in the area council B. There's no pre-existing section 117 obligation. The section 117 obligation would arise at the time of the person's discharge from hospital. And immediately prior to that, on a SHA basis, that person was ordinarily resident in Council B. So, I mean, my take on it would be that while you would disregard the period of time in Council B for the purposes of any, essentially, if that person didn't actually require any mental health aftercare follow-up, they actually would go back to Council A for Care Act purposes, because you would disregard both the time in NHS, you would disregard both time in hospital and the time in Council B, and you would go back to the time in Council A. But if it's section 117, there's no reason to disregard the time in Council B because they were only placed there under the Care Act. There's no pre-existing, which I think just goes to the absolute nightmare that local authorities are going to be finding themselves in, because I mean, there are all of these interlocking pieces on it. And I think just one point to add to what Sean was saying is, well, one of the points that was picked up certainly by Lyndon J in the first instance judgment, I think somewhat less by the Court of Appeal, was the section 117 duty is only discharged under section 2 when both the local authority and the CCG have jointly made a decision that the person is no longer in need of services. And I think this is really one of the questions in terms of what was run by Worcestershire in the case, was saying, well, we gave up the accommodation in Swindon. Isn't that enough to show that there were no more section 117 aftercare needs? Because the way that we were meeting aftercare needs was by providing this accommodation where JG had gone back into the hospital for years on end. She didn't require that accommodation. We gave it up. Isn't that enough of a decision? And I mean, I'd be curious for your take, but I mean, I don't think Lyndon J felt that he fully needed to reach that decision, but I think he was leaning pretty strongly towards, no, not really. Giving that up isn't just simply terminating a contract, isn't the same as saying this person has no more aftercare need.
Yeah, and I think that has to go back to why aftercare is provided in the first place. The reason aftercare is provided is to prevent a deterioration of someone's mental disorder. And to say that they are no longer in need of services, I would suggest requires something more than what I think Lyndon J thought was an administrative act of effectively giving notice, terminating a placement. But I do think that there is a really important point here, and that's at the point at which someone is qualifying for 117 support, actually identifying what their aftercare needs are, being very clear about what needs are aftercare and what needs might be care and support under the Care Act, for example, because it's going to be very difficult to discharge a duty if the basis on which the duty was accepted in the first place isn't known. In other words, if you haven't worked out what someone's aftercare needs are, how are you going to be in a position to say, well, actually, those needs have been met and they don't need aftercare anymore? So that's my cautionary note, I think, for this session.
And one of the points that I think will be interesting, I mean, and JG herself is actually a pretty good example of this. When she went back into hospital after her time in Swindon, she was in there for 2 years. And I think there is one point where you look at it and say, after this person has been in hospital for a year and there's no plans to discharge them, what are we doing with aftercare, really? And I mean, I feel like that's probably something that would need to be explored, because I think there is on one hand the question of, if a person is going in, for a brief period of stabilization of medication. They need to stay there long enough to be under Section 3, but really we're talking about sort of a 6-week admission. You're not going to give up on the community arrangements for that person, because you're still very actively looking at this as a person who is coming back to the community on a very short-term basis. But I mean, an admission of years, I mean, are you really going to keep looking at all the community plans for a person in the absence of any real prospect of them returning to the community? I mean, I don't know what your takes on that are.
I mean, to not do so would potentially be contrary to the Mental Health Act Code of Practice. But an interesting question. Jack, anything you want to add?
No, I mean, as I say, I think the question about the degree of formality that's going to be needed in relation to decision making and how it should be recorded and communicated, I think is one that practically is going to need potentially revisiting in a lot of authority areas, because often it is quite an informal sort of process. And I think that the steer from Worcestershire is that won't cut it. As I say, I do think there may be circumstances in which a court might accept that there is or maybe willing to infer a decision if it's clear across the board, as it were, that there's no longer any support need for a period of time. But often it's going to be a lot murkier than that.
All right, well, I think we probably have to bring it to a close there. So just to say thank you very much to all of you who've attended and who've asked us some really quite interesting questions, obviously stimulated a lot of discussion. And thank you, of course, to Jack and to Arianna for their presentations. You will be able to get access to the recording and the slides, which will be sent out. Thank you all very much and good afternoon.
Thank you.